All right, the next case set for argument is Adam Peters et al. Versus Akron General Medical Center. It's case number 29-479. Both parties are represented by counsel. I'll let you get situated here. Each side will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. I don't know if you were here when I was explaining the TV screen, how the clock works, but the total time of 15 minutes at the top of it's 5 minutes. If you reserve 5, that's you're into your rebuttal time. We don't use names of children or victims. Don't think that applies here, but we do video the arguments, and they are played on the court's YouTube channel, so we ask that you stand at the podium and keep your voice up. Again, remind you, let me know how much time you are going to reserve, if you're going to reserve time. Having said all that, we have read the briefs, and we are prepared to proceed if you are, counsel.
Thank you, Your Honor. I would like to reserve 5 minutes of my time, please.
Very good. I'll let you know when you get close.
I apologize for bringing water to the podium. I'm on some medication that tends to dry me out.
That's fine.
May it please the court. The concept of a cognizable event for a malpractice action is really one of notice. Notice that a medical procedure somehow resulted in an injury to the complainant. You have to be able to connect the dots. And in this case, the trial court looked at only one dot, one piece of information. And from that one piece of information, the trial court concluded that Mr. Peters was on notice that a medical procedure may have injured him, or that there was a relationship between the two. That's a problem in this case, because relying on that single bit of information is not enough for anyone under these circumstances to be able to connect the dots. That piece of information, of course, is the presence of a vascular clamp in Mr. Adams' leg after he had a very extensive, complex surgery on his leg. He learned of it at the same time that his orthopedic surgeon learned of it. It was in a consultation prior to a second surgery to install a knee replacement of the knee. Dr. Glass, his orthopedic surgeon, shows you the x-ray and says, there's something there. Her partner says, might be a vascular clamp. And that was the extent of the information that Mr. Peters obtained. From that, the trial court concluded that that was the cognizable event that led to the accrual of the claim for purposes of the statute of limitations.
Was he experiencing any pain, discomfort, or having any complaints about that part of his leg where the clamp was?
Well,
I know he went in for a knee replacement.
Right, he was injured in an industrial accident, Your Honor, which did tremendous damage throughout his leg.
You're talking about the first surgery?
Well, the first surgery actually was to prepare for the second. The muscles were so damaged that blood flow was compromised in that area, so they had to do a graft in order to have healthy muscle tissue there with enough blood supply that they could do the knee surgery.
Okay.
So, yeah, he generally had problems because they had just in that area cut out a big piece of muscle.
So they were related, the two surgeries?
The two surgeries were directly related. The first was kind of a preparatory surgery, if you will, for the knee replacement.
Thank you.
And this is one of the facts that comes into play because he's got a lot of stuff going on down there. The surgeon, Dr. Glass, this is the consultation prior to the knee replacement, sees the clamp. It's a clamp. Her testimony is clamps are properly left in patients all the time. I didn't think there was anything odd about having it there. And I certainly didn't think there was any issue with proceeding with the total knee replacement with the clamp there. She further testified she did not believe that that clamp could be a nidus for future infection. She never gave Mr. Adams, or Mr. Peters, excuse me, an indication that there was something wrong with the clamp being there, or that he should speak with someone, Dr. Peterson, about whether it should have been there or not. He was given a piece of information by Dr. Glass. He was not given any indication that that piece of information should be acted on. This court and the Ohio Supreme Court have both held that a patient is entitled to rely on their doctors during the course of care. And I believe that covers not only what the doctor says, but how the doctor acts. The demeanor, the way things are communicated. If Dr. Glass had said, "Oh my gosh, there's a clamp there," that's one thing. If she says, "Well, there's," as she testified, "I just said there was a clamp there and that was that." There was no indication that Mr. Peters was on notice that there could have been a problem with the clamp. The other thing is, not only must he know that there's a problem, that the clamp shouldn't have been there, that there was a negligent act in leaving it there, he had to be able to relate it to an injury. He wasn't suffering from any complaints that, other than what was going on with the rest of his knee.
That was sort of my question when I started out.
Right. He's got no idea that, excuse me,
That the clamp was causing.
that there's a problem to begin with, let alone that the clamp could be the source of the problem. Like I said, it's a matter of connecting the dots. And the trial court, in placing all of its reliance on a single point of information, imposed upon Mr. Peters the duty to understand all possible ramifications of that. Well, one, that's a little bit unfair. Two, Dr. Glass looked at it with all of her medical training and expertise, and she didn't think there was an issue. To require Mr. Peters to have a crystal ball in a case like this is really quite unfair. I want to go on to the statute of repose and how that issue plays into this case. The statute of repose puts an absolute 4-year bar on claims, with exceptions. The first is the one that applies here is that if you discover the foreign object or the malpractice not in the 3rd year but in the 4th year, you have 1 year from the date of that discovery to file your claim. I laid out the timeline of this case in my initial brief to help the court identify the specific dates where various events occurred. But in this case, the issue with respect to discovery of the object, the statute says it's 1 year from the discovery of the foreign object. Now, foreign object is not defined in the statute. We know
Isn't that the 1-year statute limitation that talks about 1 year after discovery? The statute of repose
of
4 years after the act, doesn't it?
4 years after the act, 1 year after the discovery of the foreign object. Two things, Your Honor. One, as I was saying, it's one thing to know that an object is there. It's another thing to know that the object is foreign. That is, it shouldn't be there. And I'm referring to the Busco decision out of the 8th District. Not sure if the court was aware, but the Ohio Supreme Court declined to accept jurisdiction over that case last week. So the Supreme Court was presented with the issue and it decided not to accept it. And that goes back to just the idea of, was there a reason for Mr. Peters to think that the clamp shouldn't have been there? And I think if you consider all of the circumstances of the case, one could easily conclude that he shouldn't have been able to conclude back in June of 2013 when Dr. Glass showed it to him that it shouldn't have been there. And that really is the point. So that he, even under the statute of repose, he falls within the 1-year period because although he knew the object was there, he didn't know it shouldn't have been there. And he had no notice, no ability to relate the presence of the clamp as being one that shouldn't be.
Did the trial court grant summary judgment based on analysis of the statute of repose or based on analysis of the statute of limitations?
The analysis, Your Honor, appears to have been solely of the statute of limitations. My recollection of the trial court's decision, it did not go through any separate analysis of the statute of repose. However, when it reached its conclusion, it did reference the statute of repose, but there was no analysis performed by the trial court.
Counsel, you're at 4 minutes and 22 seconds total time. You want to reserve that or continue?
I'm going to reserve that, Your Honor.
All right,
Thank you.
you'll have 4 minutes and 22 seconds for rebuttal. Counsel, you'll have 15 minutes.
Good morning, Your Honors. May it please the court. My name is Erin Host. I'm here today on behalf of FLE, Dr. Parker. I'd like to reserve 11 minutes, and then the remaining time will go to remaining counsel.
All right, hold on 1 second. I just noticed there were 2 appellants here where you would split 15 minutes.
There are 2 FLEs.
Yeah, I think this,
Our sheet's wrong. Okay,
Yeah.
that's okay.
Yeah.
That's okay.
Yeah, there should be 2 FLEs.
All right, I'll continue that. Go ahead.
Thank you. Your Honors, Appellant Adam Peters' medical claims against Dr. Parker are barred as a matter of law. To be clear, in this case, we're here on summary judgment, and there's truly no issue or dispute of material fact. Instead, we're here on a purely statutory interpretation issue, statutes that have been long settled and long applied, and now appellant is here asking that we apply it in a different manner than the legislature intended. So as to the undisputed facts, appellant does not dispute that he discovered that there was a surgical clamp left in his leg in June of 2013. He also does not dispute that several weeks earlier, in March 2013, he had a procedure that was performed by Dr. Parker. Finally, appellant does not dispute that he waited until December 2017, more than 4 years after he discovered the presence of the clamp, to bring suit against Dr. Parker based upon medical claims. Based upon these undisputed facts, the trial court did not err in granting summary judgment to Dr. Parker based upon the inherent time-bar nature of these medical claims brought in this suit. So first and foremost, as this court is aware, RC 2305.113A provides for a 1-year statute of limitations that governs medical claims. Ohio law is also well settled within this same statute that when there is specifically involving a foreign object, it is the discovery of the foreign object that triggers this 1-year statute of limitations. What appellant is asking this court to do is to read a subjective element into the statute that is simply not there. If we turn to the actual language, we see that if the alleged basis of a medical claim is the occurrence of an act or omission that involves a foreign object left in the body, the person making the claim must commence the action not later than 1 year after the person discovers the foreign object. There is no provision within this statute providing that the statute of limitations is told unless and until an individual discovers that there's harm arising out of the foreign object, or that there must be some kind of physician who specifically tells them that the object is not supposed to be there. Instead, the statute imposes a burden upon an individual to pursue whether or not, or involve a discovery, whether that foreign object should be there or not. In other words, the individual has a duty to inquire further, which appellant here does not dispute that he never did. So after he meets with another physician in June of 2013, and he is told that there is a foreign object in his body, he's told there is a surgical clamp left in there, he never returns to Dr. Parker or any other physician to inquire, to follow up on whether or not it should have been left in his body. So at this point, he's aware that there's a foreign object left behind. He never follows up, he never does anything further. Because that is the date in 2013 when he was aware, pursuant to the legislature's intent, that is when the statute of limitations begins to run. And this is because foreign object claims, a very specific subset of medical claims that the legislature has provided for, is based upon the very fact that the object is not supposed to be there. So once the object is discovered, that's when a plaintiff's time starts to run to bring a medical claim. For example, the Ohio Supreme Court held in Melnick v. the Cleveland Clinic that to carelessly leave a large and obvious metallic forceps and a non-absorbent sponge in the surgical patient's body is negligence as a matter of law. This is the act of negligence we're talking about. The very fact that an object was left there. That is when the statute is triggered, Your Honors. So because appellant here waited well beyond the 1-year statute of limitations following his March 2013 discovery, his claim is time barred as a matter of law pursuant to 2305113A. In addition, his claims are explicitly barred by Ohio's statute of repose. The Ohio Supreme Court has held that this is an absolute statute, which
I will ask you the same question. Did the trial court base its granting of summary judgment on the statute of repose or the statute of limitations for both?
A reading of the opinion, Your Honor, demonstrates that their analysis was of the statute of limitations. They don't necessarily go into an in-depth analysis of the statute of repose, but because we're here de novo, and because, appellant has raised it as an assignment of error, this court is able to address it. So in contrast to the 1-year statute of limitations, the statute of repose bars any claim brought more than 4 years after the act or omission giving rise to the injury. Again, the object was discovered in 2013, March of 2013. Claims were not filed until December of 2017, 4.5 years after discovery. The purpose behind Ohio's statute of repose is very important here, Your Honors. The purpose, as intended by the legislature and as recognized by the Ohio Supreme Court, is that medical providers are to have certainty and a time after which they may be free of the fear of litigation. In order to effectuate this intent, courts are to interpret the statute as it was enacted and not attempt to circumvent, based on a judicially created discovery rule, to circumvent these legislatively imposed limitations. So because Mr. Peter's surgery occurred in March 2013 because he then discovered several weeks later, in June of 2013, the object left in his body following this March surgery. Any claim had to be brought within 4 years of those dates. It was not brought until December 2017, Your Honors. The Ohio Supreme Court has made clear that the statute of repose is an absolute bar, and it was intended to be so. So therefore, his claims are barred both pursuant to the 1-year statute of limitations and pursuant to the 4-year statute of repose.
So are you indicating that the trial court does not need to consider whether the condition, in this case the clamp, would put a reasonable person on notice of the need for further inquiry? Are you saying that's not a factor that should be considered by the court?
No, Your Honor, that's not what I'm saying. So if we look to the actual language of the statute, what you just pointed out, it is provided for. So it's when the person actually discovers or when a reasonable person exercising reasonable care and diligence would have felt the need to follow up and inquire further. So there is a reasonableness standard here, but Your Honors, the reasonableness standard is met here. If we look to the testimony provided to the trial court, Mr. Peters specifically said that he had no idea whether or not that clamp was supposed to be there. His testimony is entirely devoid of any follow-up. He never inquired to the physician who told him the clamp was there, whether or not it was supposed to be there.
But what would cause him to be on any notice that there was an improper medical procedure by leaving that clamp in there? I mean, clamps are left in people all the time after surgeries.
Correct, Your Honor, but it is the very fact that an object was there that triggered his duty to follow up. So for example, if you go to the doctor and you had a procedure a few weeks earlier and they see something on an x-ray, they see a clamp, that triggers your duty to then follow up, was that clamp supposed to be there? A plaintiff is, should be aware of what care they were provided and what the intention of that procedure was.
So again, there's no reasonable person test for that? Would a reasonable person know that, hey, that clamp shouldn't have, and in there you're saying that they have to follow up with the original doctor just because a clamp was noticed?
Correct, Your Honor. The
Even
statute
though
provides...
there is no evidence that anybody expressed concern or, I guess would a reasonable person, given the facts that we have here, go back to that original doctor and say, hey, is this clamp a problem? Or are they going to trust their doctor and figure, hey, clamps are used in these cases all the time? I'm just thinking about, does a trial court need to pursue that type of an analysis in determining if this is a cognizable event?
To the extent a cognizable event, the legislature has made clear that there is no subjective element read into this statute. So even, trying to attempt a reasonable person standard, we have to read the statute as written.
And when you're reading the reasonable person standard in the statute, you're reading it in subsection D3. Is that where your argument is coming from, where it says a person who commences an action on claim is the committed burden of proving by clear and convincing evidence that the person with reasonable care and diligence, is that the reasonableness that you are talking about in response to Judge Teodosi's question?
Yes, that is the only reasonableness, which is not, to clarify, it's not a reasonable person standard, it's reasonable care and diligence. So there must be follow-up. The statute requires follow-up, Your Honor.
And then from that, it says, could not have discovered the injury resulting, as opposed to discovered the foreign object, period.
Well, Your Honor, to your point, we have to read 2 and 3 in conjunction.
I understand that. I guess that's what I'm asking. So when it says, could not have discovered the injury resulting from the act.
Right, so Your Honor, the act that we're talking about is the act contained in number 2. And the legislature has made clear that the negligent act is the mere leaving of the instrument, not harm arising out of the instrument, the very fact that the instrument is there. That is the negligent act. as determined by the legislature and as case law has interpreted. So it's not necessarily you sit and you wait for an injury to arise, say 20 years down the line. It's the very fact that the instrument is present that is the negligent act.
Counsel, you're at a total time of 3 minutes left. I don't know if you want to.
Now, I'll reserve your time for remaining counsel.
All right, very good.
Thank you.
That's what happens when you go second.
I'm used to it.
Hold on 1 second. I should. There's this one. Then. All right, you've got 3 minutes left.
Thank you, Your Honor. May it please the court, my name is Brian Sullivan. I have the pleasure of representing Dr. Peterson in Akron General Medical Center in this appeal. I think there's no dispute. I don't think there can be any reasonable dispute that this case involves a foreign object. In fact, paragraph 13 of plaintiff's complaint specifically alleges that defendant's failure to take into account to remove the foreign object from his leg caused injury. I think our Ohio law is crystal clear under Revised Code Section 2305.113D2 that if the alleged basis of a medical claim is the occurrence of an act or omission that involves a foreign object left in a body, the person may commence an action upon the claim no later than 1 year after the person discovers the foreign object. I don't think there's any dispute that Mr. Peters here discovered the existence of the foreign object on June 4, 2013, when he met with his orthopedic surgeon. She put the x-ray of his leg up on the wall and said, that's interesting. Looks like a metallic clamp there. Can't explain it. I don't think it has any impact on the knee replacement surgery that I'm going to provide, or that I'm going to conduct. But it's clear that he learned of the existence of the foreign object in June of 2013. And I think under subsection D2 of 2305.113, he has an obligation to investigate that claim to the extent that it exists and file a lawsuit within 1 year of learning that information. And I would submit that subsection D3, Your Honor, places a heightened burden on him to demonstrate by clear and convincing evidence that he engaged in a reasonable inquiry to pursue that claim. And so I think whether this court analyzes it as the trial court did under the statute of limitations or under the statute of repose, which I think provides an alternative basis within which to affirm the judgment in favor of the defendants, the court can only come to the conclusion that the plaintiff's claim is time-barred because it was not filed within 1 year of the discovery of the foreign object. And for those reasons, we would ask that the court affirm the judgment in favor of defendants. Thank you.
Thank you. Counsel, you'll have 4 minutes and 22 seconds.
With any luck, Your Honor, I will not use them all. As counsel suggested, subsections D2 and D3 have to be read together. And as Judge Hensel pointed out, D3 discusses discovery of the injury that the plaintiff is complaining of. And that reading is consistent with the Supreme Court's, in its dicta, I'll grant you, but Supreme Court's statement in Ruther v. Kaiser that I cited in the brief, where the court noted that under sections D1 and D2, the plaintiff is provided an additional year after discovery of the injury, just as Judge Hensel was reading that provision. And then there's the Melnick decision my colleague referred to, and again it discusses the time period for discovering or should have discovered the negligent act, and this goes back to the concept of the foreign object. Under my colleague's interpretation, the knee replacement performed on Mr. Peters, well, that resulted in a foreign object. Well, that's not the way the term foreign object has been interpreted, and this is, again, referring to the Busco decision out of the 8th District, which reversed and remanded a trial court decision based upon, I think there was some surgical mesh that had migrated, and the question there, the court concluded was, well, you have to determine whether it should have been left there or not, and that's going to be the determining factor. And I think, Your Honor, you're correct. You have to do this weighing, and that's ultimately for a trier of fact at trial, not really for summary judgment purposes, as to whether under these circumstances, which have to be considered together, Mr. Peters acted reasonably and not not investigating the clamp that his surgeon.
Did he act diligently? It says reasonable and diligent.
Reasonable and diligent. Well, Your Honor, that's a question that I think you have to consider a lot of things on, about. And under the circumstances, how would I have acted? I don't know that I would have acted any differently. Does that satisfy the standard? Well, maybe yes, maybe no, but I don't think that could be determined on summary judgment. I think this is an issue that needs to be presented to the trier of fact in open court. And with that, the appellants ask that the court reverse the decision of the trial court and remand for further proceedings.
All right, thank you, counsel. Thank you both for presenting your arguments today. The court will take the matter under advisement and issue a decision in due course. Clerk of courts will mail you each a copy of the decision on the date it's released. And as I'm sure you both know, the opinions are also available on the Supreme Court of Ohio's website. Again, we really appreciate when parties come down and argue. Gives us an opportunity to ask questions and get some further input. So thank you both for your attendance here today.
Thank you.